Hey y'all, it's Kim. So this is another court document from Jeffrey Epstein, the document dump they just did for 2025, and we still don't have any prosecutions on this damn thing except for Ghislaine, and then I guess Jeffrey Epstein basically got away with it because he died. But we know if you have a spiritual mindset, you know he's being taken care of. So okay, anyway. But let's see. So this is United States District Court, Southern District of Florida. Plaintiff is CL. I'm not sure which one that one is. And then versus Jeffrey Epstein, the defendant. Defendant Epstein's motion for more definite statement and to strike and dismiss directed to count 3 of plaintiff CL's complaints. And then date of whatever, 3/31/2010. Defendant Jeffrey Epstein, by and through his undersigned counsel, files this motion for more definite statement and strike and motion to dismiss count 3 directed to plaintiff CL's complaint. Rule 12B6, Rule 12E and F, something on a federal something, some law shit. Sorry. In support of his motion, defendant states the complaint attempts to allege 3 counts, all of which are purportedly brought pursuant to 18 USC subsection 2255 civil remedies for personal injuries. Defendant seeks more definite statement of the precise time period during which the alleged conduct by Epstein involving plaintiff occurred and seeks more definite statement as to CL's date of birth so he can determine when she was no longer a minor. Plaintiff's complaint fails to state even these rudimentary facts, as discussed more fully below herein. When Epstein's alleged conduct involving CL occurred, determines what version of 18 USC subsection 2255 applies to this action. To be clear, defendant recognizes that pursuant to the NPA, the non-prosecution agreement, he cannot. Sorry. What happened to this thing? Shoot. Where did it go? Why is it going so far? Sorry, guys. Hold on. Okay. He cannot challenge the standing of plaintiff to bring an action exclusively under 18 USC subsection 2255 or raise certain defenses as long as the action is brought exclusively under 18 USC subsection 2255. In addition, Epstein, pursuant to the NPA, does not contest this court's jurisdiction and waives liability as required by paragraph 8 of the NPA as to a predicate act or acts under subsection 2255. And I think I do have a video about the non-prosecution agreement. It's not a very long document, but you go back and look at it. Basically, it screwed those girls over. He couldn't be prosecuted. So anyway, and then anybody involved pretty much couldn't be prosecuted. It's just like crazy. But anyway, so that's why we're not getting a lot of prosecutions, which that should have never happened in the first place. But okay. However, the NPA does not prevent defendant from asserting what version of 18 USC subsection 2255 applies for purposes of establishing a minimum statutory damage recovery and whether one of the 3 specified predicate acts which was enacted subsequent to the completion of the defendant's alleged offense conduct with allegedly injured the plaintiff. This is so crazy. Hold on, where did it go? It keeps messing up here. I keep screwing it up or something. Okay. Okay, conduct with allegedly injured the plaintiff can be applied in the face of constitutional ex post facto prohibitions to criminal offenses that were not in effect at the time of the conduct at issue. See footnote 1 herein regarding Epstein's obligation to honor the terms of the NPA. So I guess they could bring certain actions against him, but for the most part, he wasn't really convicted of anything. And then he got, what was it, like 13 months probation. He got to go home at, what was it, at night or something. Or no, he got to go home during the day and work at his home in Miami and then came back to the prison at night to sleep. It was like the craziest thing, or the jail. This man got away with so much. Anyway, to the extent that the conduct alleged by plaintiff occurred prior to July 26, 2006, or 27th, 2006, excuse me, count three is subject to dismissal because the predicate act relied upon by plaintiff for her claims that did not come into effect until July 27, 2006. Defendant's attorneys are 100% certain that plaintiff, in being required to assert basic pleading requirement of time for the alleged acts, will allege that the conduct took place prior to July 27, 2006. Defendant notes that through his undersigned counsel's review of the town of Palm Beach Police Department file produced in discovery that CL was meeting with the police in December of 2005. That CL's date of birth is April of 1988, thus 18 and not a minor as of the time of the enactment of the predicate offense under which count three is based, and that she claims she was at defendant's home in 2004. By the court requiring that plaintiff plead such allegations, plaintiff will determine that she has no cause of action in count three as a matter of law. While this court obviously has not yet ruled on the motion for a more definite statement, defendant is presenting his argument to count three, knowing that plaintiff can and should concede the missing elements of time and birth month and year in her response. Anyway, pretty much trying to get out of it. Okay, so let's see. Supporting memorandum of law, motion for more definite statement and to strike. Rule 12E and F, FRCP. I don't know what those stand for, but plaintiff alleges that beginning in or around 1998, excuse me, through in or around September 2007, defendant uses his resources and his influence over vulnerable minor girls to engage in a systematic pattern of sexually exploitive behavior. In 1998, she would have only been 10, but I guess they're just talking about that's when all of this started taking place. Complaint 10, CL further alleges that she originally introduced to defendant when she was 15 years old. There are no allegations in the complaint as to plaintiff's date of birth or as to the time period during which the alleged conduct by Epstein involving CL occurred. Such allegations are critical as it determines what version of 18 U.S.C. subsection 2255 applies to this action. As discussed more fully below herein, 18 U.S.C. was amended effective July 27, 2006. Defendant also seeks to strike or more definitely state 8, 9, 10, 11, 12, 13, 14, and 15, such that the allegations pertain to CL and not other alleged victims, or what Epstein's alleged conduct was with respect to other alleged victims. Such allegations are immaterial and impertinent as are not related to plaintiff CL's claim. Plaintiff should allege those facts that specifically pertain to her. Not until 16 does plaintiff assert allegations pertaining to her and the conduct of defendant directly involving her. What Epstein may or may not have allegedly done with respect to other females does not affect plaintiff's claims brought pursuant to subsection 2255. So apparently she's trying to lump everybody together in her complaint, but it really has nothing to do with that. I don't know. I guess that's the whole point of this, or what they're trying to fight against. But if you go back and look at one of the last videos, not the photos, but the one before that, there's basically this CL versus Epstein, and it's talking about all the allegations. We'll just say that. Okay. The same lawyers that represent plaintiff CL also represent plaintiff BB in action filed against Epstein in state court. Case number 502-008-CA-0373-19XXXMB-AB, 15th Judicial Circuit Court in for Palm Beach County State of Florida, it appears that plaintiff's counsel carelessly used the BB complaint as a template for this action, even though different causes of action are asserted therein. At one time, the BB action attempted to include a Florida RICO claim, which has now been voluntarily dismissed. Okay. Plaintiff's counsel, by including allegations as to other plaintiffs and other alleged girls, was attempting to improperly assert a RICO claim in BB. Such immaterial and impertinent allegations in the BB case are also are also the subject of a motion to strike. Reference to a scheme, pattern, and plan are immaterial and impertinent to CL's claim. Plaintiff is not allowed to argue other alleged plaintiff's cases. The CL action is brought exclusively under 18 U.S.C. subsection 2255. The allegations in 8 through 15 are not related to the elements of plaintiff's subsection claim and thus are required to be stricken and or repled to more definitely state the alleged facts specific to CL. Motion to dismiss count 3. Because Epstein's conduct occurred prior to July 27, 2006, and plaintiff is relying on a statutory predicate act that was not enacted until after July 27, 2006, count 3 is required to be dismissed. Plaintiff is relying on a criminal predicate, 18 U.S.C. subsection 2252A, subsection G or whatever, that was not even in existence at the time of the alleged conduct by Epstein, directed to CL, which would clearly violate the Ex Post Facto clause of the U.S. Constitution. Don't know what that is. Maybe I'll look it up. Not right now. Okay, as noted above, defendant is certain that when plaintiff is required to more definitely state her claim, and allege facts as to time and conduct, acts specific to her, the date of the acts alleged will be prior to July 27, 2006, and thus defendant will argue his position based on the fact that no alleged conduct by Epstein involving CL occurred on or after July 27, 2006. Additionally, equally important, as of July 27, 2006, CL would be 18 and no longer a minor at the time 18 U.S.C. subsection 2255A G was enacted. Plaintiff, in her response, can and should concede this issue. Let me look back at this little footnote on this page. Hold on, where's it at? At the bottom. Okay, so Epstein will fully honor his obligations as set forth in the non-prosecution agreement with the United States Attorney's Office, principally as related to the claims made in this case by CL, the obligations as set forth in paragraph 8 of that agreement. In particular, Epstein will not contest the allegation that he committed at least one predicate offense as alleged by CL. Okay, so go back down here. There's no language in the statute which suggests G is to apply retroactively. It is well settled that in interpreting a statute, the court's inquiry begins with the plain and unambiguous language of the statutory text. CBS Inc. versus Primetime 24 Venture. These are all the cases that this has come up, okay? When interpreting a statute, a court's inquiry begins with the text. The court must first look to the plain meaning of the words and scrutinize the statute's language, structure, and purpose. In addition, in construing a statute, a court is to presume that the legislature said what it means and means what it said, and not add language or give some absurd or strained interpretation. As stated in CBS Inc. Supra at 1228, those who ask courts to give effect to perceived legislative intent by interpreting statutory language contrary to its plain and unambiguous meaning are in effect asking courts to alter the language, and courts have no authority to alter statutory language. We cannot add to the terms of the provision what Congress left out. Merritt, and then Dodd versus U.S., so these are just some of the cases that's come up. So Title 18 of the USC is entitled Crimes and Criminal Procedure. Subsection 2255 is contained in Part I, Crimes, Chapter 110, Sexual Exploitation and Other Abuse of Children. 18 U.S.C. subsection 2255, which is 2002, I guess, is entitled Civil Remedy for Personal Injuries and provides any minor who is a victim of a violation of section 2241C, 2242, 2243, 2251, 2251A, 2252, 2252A, 2260, 2421, 2422, or 2423 of this title, and who suffers personal injury as a result of such violation may sue in any appropriate United States District Court and shall recover the actual damages such minor sustains and the cost of the suit, including a reasonable attorney's fees. Any minor, as described in the preceding sentence, shall be deemed to have sustained damages of no less than $50,000 in value. Any action commenced under this section shall be barred unless the complaint is filed within 6 years after the right of action first accrues, or in the case of a person under a legal disability, not later than 3 years after the disability. See in note 1 here too for statutory text as amended in 2006, effective July 27, 2006. Prior to the 2006 amendments, the version of the statute quoted above was in effect beginning in 1999. The amended version of subsection 2255 significantly changed subsection A such that it now reads, in general, any person who, while a minor, was a victim of a violation of section 2241C, 42, 43, 51, 51A, 52, 52A, 60, 24, 21, 24, 22, and 24, 23 with this title, and who suffers personal injury as a result of such violation, regardless of whether the injury occurred while such person was a minor, may sue in any appropriate United States District Court and shall recover the actual damages such person sustains and the cost of the suit, including a reasonable attorney's fees. Any person, as described in the preceding sentence, shall be deemed to have sustained damages of no less than $150,000 of value. Wow. Okay. Let me go ahead and stop here. This is getting like a little deep. I do want to look at that ex post facto, whatever that was. So we're on page 6, like right here. What was it? Something about, hold on. I just wanted to see what that was. Isn't that what it said? Something like ex post facto something. Let's see. I just wanted to Google it. I've never heard of that before. Ex post. Okay. Facto law. What does that mean? This is according to Google. It says an ex post facto law is a statute that retroactively changes the legal consequences of actions committed before the law's enactment, making something a crime that was legal. Increasing the punishment for a crime after it was committed, or altering rules of evidence to make conviction easier, and it's prohibited by the United States Constitution for both federal and state governments to protect individuals from arbitrary governmental power, ensuring fair notice of laws. Oh, okay. So it means after the fact, prohibition found in Article 1, Section 9 of Congress and Section 10 states of the United States Constitution, a purpose to prevent unfairness by ensuring people know what is illegal and the consequences when they act. The only thing I can equate this to is when they do stuff like, say, with firearms, and you purchase something, you've done it legally, you've done all the stuff, you've gone through your classes, you've done whatever, and then for whatever reason they decide to go ahead and outlaw a certain thing. That's the only thing I can kind of equate this to. It says what it does, and it's prohibited. It criminalizes the innocent, makes an act a crime that was legal when performed. And then aggravated crime changes a crime to a more serious offense after it was committed. And then increases punishment, makes penalties harsher for a crime after its commission. And then alters evidence rules, changes evidentiary rules to make conviction easier after the fact. And what it doesn't do is permitted. Civil laws generally doesn't apply to civil laws, though retrospective civil laws can still face constitutional challenges. And mitigates punishment. Laws that reduce penalties in mitius or something like that are permitted. And then repeat offender laws. Habitual criminal statutes where past crimes are used to impose a harsher sentence for a new crime are generally allowed because they punish the latest offense, not the past ones, as clarified in cases like McDonald versus Massachusetts and Greiger versus Burke, according to the U.S. Constitution annotated. Okay, so it's just like kind of weird. An ex post facto law named using the Latin phrase for after the fact is a law that imposes criminal liability or increases criminal punishment retroactively. So yeah, that's what I can equate it to. Like you purchase a legal firearm, you've gone through the steps, and then eventually Congress or somebody comes up with this thing and says, "Oh, those are no longer allowed, so you have to give them away." I'm not saying that this has always happened, but I'm just giving that as the example that I can think of. You've done something that you were supposed to do, and now they're saying that you did something that you weren't supposed to do, like they changed the law and now you could be punished for it. Anyway, I don't know. So it's kind of crazy. But we're still keeping the Epstein thing going. So that's what I care about. He should not have gotten away with it the way he did, even though I know he was sitting in jail. I mean, we need other people to get arrested here, people. Anyway, we need to see some prosecutions. Pam Bondi needs to step down if she's not going to do anything about it. We need somebody in there to actually do some work. But anyway, y'all have a good afternoon. I'll see if I can get another one of these recorded, finish out that little document there, and I'll see y'all around. Bye.